We're going to talk this evening about BI claims and aggregation and the FCA case, and try to predict a little bit where things might be going in future. I'm joined by Joe, described as fantastic and having a fantastic work ethic, but by Will, who is ready to answer any question, however problematic, that applies to this evening, and is extremely forward-thinking, and by contrast, me. So hopefully we will keep you reasonably entertained whilst talking about business interruption and aggregation, if that's not an oxymoron. So is it you first, Will?
Yes, I think. Of course. Right, so my job at the beginning really is to give a very short recap of the FCA case and to really set the scene for my colleagues to then develop in terms of where things have moved since then. So I know some of you will be intimately familiar with the case, some of you maybe less so. So I apologise to the extent that I'm recapping, but hopefully there'll be something that you can pick up from it. So the very short headline of the case is that the Supreme Court held that the disease causes did cover business insurance resulting from COVID-19 generally, as long as at least one case had occurred in the radius covered by the clause, and that for cover to exist under prevention of access clauses, the insured had to show a complete inability to use the premises or a discrete part of the premises, or the same in respect of a discrete part of its business, and in respect of the trends clauses, that it was necessary to exclude circumstances arising out of the same underlying causes as the insured peril. So it was wrong to adjust for other effects of the pandemic. Now, it's impossible in the short time I have to do justice to the extensive reasoning of the Supreme Court in the case, but I want to pick up two points. Firstly, to look at the way in which the insured peril was construed by the Supreme Court, and then in light of that construction, how causation was considered. And I think it's in this second aspect in relation to causation where the Federal Court of Australia on appeal reached a different conclusion, and I want to look briefly at why that was in the second part of the talk, and what that might point to going forward. So firstly, though, I think it's worth just bearing in mind the factual context in which this case was being decided, because for most of us, with the exception of the person in the picture, the COVID-19 restrictions might be fading a little bit more into the background. And it's worth bearing in mind that, firstly, that COVID-19 was extremely contagious, but not usually resulting in serious illness. And so as a result, you had a wide incidence of cases around the UK, but any one case on its own would be unlikely to require restrictive measures to be imposed on businesses. So in other words, it was a combination of lots of widely spread cases which led to the restrictions. So it was categorically different, you might say, to something like Legionnaire's disease, which if found might require closure of a business in the locality for a temporary period to implement contingency measures and then reopen. And the second fact is that the government took a number of steps and gave a number of instructions or guidance rather than law, and the regulations then would catch up with those instructions or guidance, which created a grey area of time in which businesses were instructed to close, but the closure could not be legally enforced. And then the final fact that I think is important context is that the closure measures were often something short of the entire business having to shut down. For example, you might have a restaurant able to buy takeaways, or the shop might have been able to keep the pharmacy open, and so the court had to bear that in mind. And so against that backdrop, the Supreme Court had to apply whatever conclusion it came to on construction and then determine whether the insured peril had caused the loss. And when you look at the way that the Supreme Court approached construction and the way in which it departed from the High Court's consideration of the same, I think it's important to bear in mind the background to that and the trilogy of cases sitting behind it that the Supreme Court had considered over the past decade that everyone will be familiar with, sort of Rainy Sky, Arnold Wood. And I think that the Supreme Court was alive to the idea of being seen to implement those principles and not to reopen that Pandora's box of how the construction of contracts should be approached. And I think that may be behind the reason why the Supreme Court reached a different conclusion as to the insured peril. Okay, so let's look at the construction of the business interruption clauses. And firstly, the disease clauses. So all of the disease clauses contain wording something like any occurrence of a notifiable disease within a radius of 25 miles of the premises. The Supreme Court decided that true construction of these clauses was different to the High Court, who had construed the insured peril as a notifiable disease of which there is any occurrence within the relevant geographical area. The Supreme Court found that that construction was not available. The words had a clear meaning, and the High Court's construction would be to rewrite the words that the parties had used, and that would be to do the thing that the Supreme Court was very concerned not to do. So, firstly, they considered what the word occurrence meant, and held that it meant something happening at a particular place and time, and that each incident of illness was a separate occurrence. And once one had that in mind, the clause could not be referring to cases which occurred outside of the relevant area, which were not part of the insured peril. So the proper construction was that the insured peril was business interruption caused by any cases of illness resulting from COVID-19 that occurred within the relevant area. Now that application of construction was followed through to the prevention of access clauses, and those clauses in general had a causal chain of requirements. Firstly, some interruption or interference due to, secondly, some public authority restriction or action, and then thirdly, due to a notifiable disease within the specific area. The disease element had the same construction. In relation to interference or interruption to the business, many of the clauses would include wording such as an inability to use the business premises. The Supreme Court held that those words are clear and had to mean a complete inability to use, in distinction to the High Court, could not refer to some sort of hindrance generally. So you had to find either a complete inability to use the whole of the premises or some discrete part of the premises that you could circumscribe and then find a complete inability to use that, or alternatively, a complete inability to carry on some discrete part of the business or the whole of the business. And then finally, in relation to restrictions imposed by the public authority, the Supreme Court considered that a reasonable person in the position of the parties would not understand this to require the existence of a valid legal basis for the restriction. So the restrictions need not have the force of law to satisfy that aspect of the causal requirement. And I think it was important to that finding that the Supreme Court had in mind circumstances, for example, a health inspector instructing premises to close on the basis that they're going to go into court to get an injunction, and that the parties would have expected that the business would have closed then and not wait for the injunction to follow sometime later, and that one wouldn't expect the policyholder to scrutinise on each occasion the foundation of the instruction to determine whether they should close, and if they did, whether they would be covered or not. So finally then, on construction, looking at trends clauses, which I just mentioned briefly for completeness, the argument was that because the insured peril was the individual case or cases of disease occurring in the relevant area, therefore the turnover should be adjusted to take into account the effect of other occasions of the disease outside of the relevant area, which were not the insured peril. And again, that question had been sidestepped by the court below, because if you construe the insured peril to be COVID-19, of which there's at least one occurrence within the relevant area, then clearly you can't take into consideration trends effects which include the course of COVID-19 outside of the area. So the Supreme Court decided this, consistent with its reasoning on causation, which I'll turn to in a moment, that a reasonable person would not consider the parties had agreed that cover would be adjusted to take into account circumstances which had the same underlying cause as the insured peril. So in other words, you seem to step to this second level of causation where you look first at what the insured peril was, but then at all collection events which had the same underlying cause, and if any of those had affected the trend of the business, then they should be disapplied from the trends clause. So in overview, all of these findings on construction created a difficult problem for the court on causation, because if the insured peril was only the occurrence of cases within a limited geographical area, could they be said to have caused the loss to the business that was caused by the interruption following government restrictions applying to the whole of the UK. And as Lord Briggs put it, could the court rescue the policyholders from the at first sight sombre consequences of a narrow definition of the insured peril by a principled application of the doctrine of concurrent causes? We'll see in a moment that they could. Lord Briggs claimed that that was not to rescue the parties from a bad bargain, but in converse did flow from a principled application of the doctrine of concurrent causes. So let's look at causation. And firstly, the first step is to set out some of the principles that the Supreme Court's covered in relation to that. And firstly, whether something's regarded as a cause at all involves an element of construction of the parties' agreement, as well as a factual inquiry. The contracts use language such as following, as a result of, arising from. The Supreme Court said that that made no material difference. So the starting point for cover to apply is that the insured peril must be a proximate cause. That flows from section 55(1) of the Marine Insurance Act, which is generally applied. And the Supreme Court reminded us that proximate had developed to mean proximate in efficiency rather than in time, which is where the concept had started. So once we have those preliminaries, we have to look then at the but-for test, which generally would apply to establish factual causation. And that's important here because the insured could not say that but for the occurrence of the insured peril, the loss would not have occurred. The Supreme Court recognised that there were difficulties with the but-for test. Often it would return false positives because it would capture a range of factual causes for which no legal causation would follow. But importantly here also are false negatives. And the Supreme Court gave a number of examples of where false negatives would nonetheless be regarded as proximate causes, and then develop that reasoning to get to their final application of multiple concurrent causes. So I just want to take you very quickly on that journey. They started by looking at hypothetical scenarios such as the two fires case. We have two fires, each of which would have caused the same damage to a house, but neither of which would satisfy the but-for test. But nevertheless, as a matter of legal causation, both of the fires are regarded as a cause of the damage. And that would also apply to the two shooters case. If you have two shooters, both of whose bullets would have killed the man, then neither of them will satisfy the but-for test, but both of them will be regarded as having caused the loss. You can extend that slightly further to the example given by the Supreme Court, which I call the angry bus example, which is where if you have 20 passengers, all of whom push a bus off of a cliff, but in fact you only would have needed 14 in order to have that effect, then the participation of each passenger was neither necessary or sufficient to cause the loss. An application of the but-for test would lead to none having caused the loss. And the Supreme Court said that is another false negative, because what we have there is an oversubscribed cause with more causes than we need, but nonetheless we regard them legally as each having caused the loss. So where is the boundary of that? To what extent do we continue that reasoning when we have multiple concurrent losses? And to answer that question, we step back again slightly to proximate cause and the fact that we need to show that we have a proximate cause. The Supreme Court said that is something more than just common sense. I think you can find a number of authorities where it is said that determining the proximate cause is an application of common sense. The Supreme Court said, well, no, you can articulate it slightly further, because firstly, you should identify whether there's any involvement of the peril at all. And then if there is, whether the peril made the loss inevitable, which the Supreme Court said it would hardly ever be that. And if so, whether it would be in the ordinary course of events. And developing that further, once you have a cause which is at least a potential proximate cause, to determine whether in the case of multiple concurrent causes, you have nonetheless a cause which the parties have legally agreed will trigger loss under the policy, one must look at the context and see by construing the policy what the intended effect of it was in relation to those facts. So it was said that in general, where you have many concurrent causes, then whether each will satisfy causation is not a question to which any general answer can be given. That's paragraph 190. I think it's that part of the judgment which has allowed some courts in other jurisdictions to drive a distinction between the findings that they've come to. It's on the finding of the Supreme Court that one has to look at the factual context and decide whether in that factual context, having one of many concurrent causes will satisfy causation on a true construction of the parties' agreement. So how has that been applied to the disease causes in COVID-19? Well, we're in multiple concurrent causes territory. The Supreme Court said that in England, the context was that a reasonable person would know that the new disease could spread widely and rapidly, so be unlikely to remain within the relevant area, and that the public response would be taken in respect of the whole outbreak. So it was unreasonable to apply the but-for test on a true construction of the parties' agreement. And the court was persuaded that the parties did not intend that cases outside of the area could be set up as a countervailing cause, which would displace the causal impact of the disease inside the radius, and that therefore each case was a proximate cause of all of the relevant loss, because it was a separate and equally efficient cause. So if that was the FCA case, I want to look at how this was applied by the Federal Court of Australia on appeal in 2022. And there they were considering 6 appeals. And broadly, the appeal court upheld the primary judge's finding that business interruption clauses did not cover the losses suffered because they were not caused by an insured peril. And it's important to note that the judgment says that they didn't need to consider the FCA's reasoning in respect of causation, and that what they did do was distinguish the Supreme Court's finding in relation to multiple current causes to hold that the insured peril on a true construction of the policy had not caused the loss on the particular circumstances present in Australia. So how were the circumstances different in Australia? Well, firstly, COVID-19 was not widespread at the time. So, for example, in Queensland, there'd only been 1,500 cases by the 30th of April 2021, as compared to 3.6 million in England at that time. Secondly, there's not a unitary system of government. So there are decisions taken at state level and also at Commonwealth level, which will affect business in different ways. And thirdly, that the population is not small and densely populated, such that you might have a pocket or cluster of disease, and the state might decide to take measures which are statewide, but the federal court doubted that the cause of those measures might be a single isolated case that happens somewhere else in the state. And that Commonwealth level restrictions have been aimed at preventing the influx of COVID-19, so protecting Australians from risk abroad and not to do with local cases at all. And I think it's interesting that in the first instance case, and restated on appeal, the primary judge held that it was implicit in the Supreme Court findings in the FCA case in relation to causation that there were enough cases of COVID within the relevant area to have caused the government to take the same actions with respect to at least that area. In other words, if there'd been no cases outside of the relevant area, the government would still have imposed the same restrictions in respect of that relevant area. But I'm not persuaded that that is what the Supreme Court was saying in the FCA case, because in my opinion, what they seem to be saying is that on a true construction of the parties' agreement, it wasn't possible to conduct a weighing exercise when one looked at the causal influence of cases outside of the relevant area, and you weren't to balance that against the causal influence of one inside the area to displace the one inside of the area as being a cause of the restrictions taken, which I think is a slightly different point to the one that's made by the judge in the Australian case. And it is quite important because how that played out in the appeals was that became a platform on which the Australian court distinguished FCA. So in the Tap House appeal, the court held that cases within the relevant area had not caused the state directions at all. They weren't a concurrent cause, and therefore they weren't a proximate cause. In the Meridian appeal, the court felt that the statewide restrictions may have involved the same underlying cause, but that the Commonwealth measures did not. Although the insured still failed to recover in that case because they hadn't led any evidence as to which part of their business was specifically affected by the statewide restrictions as opposed to the Commonwealth restrictions. So their appeal had also failed for that reason. And in Market Foods, the insured peril was the occurrence at the premises, and the court held that there was no evidence that statewide measures were made because of the occurrence at the premises. which again it's a slightly different lens on which to look at causation than I think the Supreme Court in England. And the court seemed to be influenced by the Supreme Court comparison when they say in FCA that you could cover the whole of England by something like 20 circles, which were the relevant areas of the disease cause, as compared to the footprint of the business premises in Queensland compared with the whole of Queensland, which is obviously a very different sort of comparison. And so perhaps more towards the example given by the Supreme Court about dropping a teaspoonful of water into a dam which is being filled up by a river and eventually overspills the dam. That is a concurrent cause, but not one which the parties would hold to be a legal cause of the loss. And then finally, in Singapore, the Singapore High Court handed down a judgment in relation to a claim by the owners of the Phuket Beach Resort against two insurers. That had been closed in the 7th of April 2020, and it's been reported that across health that the loss to the resort was covered, and so they did apply FCA. The judgment doesn't seem to be available at the moment, but it would be interesting to look at the way in which the judgment considers causation and whether it articulates the relevant factors going to concurrent cause and how they did or didn't decide then that the FCA's construction of multiple concurrent clauses should apply. So that's a very fast recap of FCA and also its application in Australia and Singapore. I'm now going to hand on to my colleague Joe to just look at that going forward.
Thank you all for coming this evening. I'm going to look at a case from last year, Corbin and King versus AXA Insurance PLC. I've done some quite detailed slides which you should have. I've resisted giving Corbin and King any free advertising by looking at pictures of the various restaurants in London, or pictures of Mrs. Justice Cockerill in them. But she will no doubt get a very good table at any of those restaurants after the result in this case. Briefly, this involved denial of access, non-damage clause, which are called NDDA clauses, in a combined business insurance policy, and it concerned business interruption losses from the government's regulations imposed in response to COVID-19 in 2020. And Mrs. Justice Cockerill held that the clauses did provide coverage. Now, we've heard some of the background to this. We're looking at the FCA's Arch case, but the relevant decision, the background for this case, was in fact the divisional court's decision, because they did deal with certain NDDA clauses containing wording such as emergency in the vicinity, danger or disturbance in the vicinity, and an incident within 1 mile. And they took the view in relation to those NDDA wordings that they did impose specific and local requirements. Of course, those were not the clauses that then went to the disease clauses that went to the Supreme Court, which you've heard about already. And as you've heard a moment ago from Will, there was in summary, a relaxation in the sense of the but-for test of causation in the Supreme Court. And although it wasn't specifically in relation to the NDA wordings, the reasoning, by analogy, was applied in this case to suggest that the matters had rather moved on since the divisional court's view of the NDDA clauses. Interestingly, before this case, AXA, of course, based parts of it in Ireland, had a case involving almost identical wording to the Corbin and King case, in a case called Brushfield versus AXA. And in the Irish High Court, they were successful in persuading the judge that the reference to danger or disturbance was not intended to extend to a pandemic and nationwide effects, and therefore had a more localised coverage. The court emphasised in Ireland that the clause referred to dangers in the insured's premises or within a 1 mile of those premises, in line with the divisional court's reading of a vicinity in the Arch case. It couldn't see in Ireland how the measures taken at a national level could have been the proximate cause of a risk of COVID-19 within a 1 mile radius of the hotel in question. Interestingly, before the decision, Mrs. Justice Cockerill last year, There was a published arbitral award by Lord Mance, which obviously would have had powerful effect. Although he didn't decide the point, this is a case called Policyholders versus China Taiping Insurance in September 2021. Although he didn't determine the point, he said obiter that he agreed with the policyholders that the NDDA extension, which provided for business interruption losses from actions or advice of the police or other local competent authorities, quote, due to an emergency threatening life or property in the vicinity of the premises, should be held to have cover, and things had, quote, moved on since the divisional court's decision in Arch, particularly in light of the Supreme Court's view we heard about causation. So, the case in question, Mrs. Justice Cockerill had to decide whether the NDA clause covered BI losses resulting from restriction on access to the insured claimant's premises, who, of course, as I said, well-known operators at lots of London restaurants, including Delaunay, Colbert, and so on. Now, the clause, I think it's in the slide, I think I can bring it up on the screen. There it is. So that's the clause in question. That's the denial of access non-damage clause. Now, Corbin and King said that this clause covered their losses because there were cases or the threat of cases of COVID-19 at or within 1 mile of each premises, which constituted a danger there or within 1 mile of each of them. Such threatened cases combined with actual and threatened cases elsewhere in the UK was the effective cause of the passing of the lockdown restrictions, which led to the restriction of access to each of the premises. Therefore, each actual or threatened case was of equal potency and a separate and effective cause. AXA said that the clause should be construed in line with the divisional court's view in Arch of these clauses. It provided a narrow, localised cover in respect of a danger or disturbance specific to where the insured's premises was, or a 1 mile radius thereof. Corbin and King, as I indicated earlier, argued that things had moved on since the divisional court's decision in Arch. So the result was that the clause did provide coverage, and interestingly, another part of the decision, which often doesn't get so much coverage on the quantum, is whether the policy was a composite policy and insurers were bound to identify each of the claimants in respect to each of the premises, or whether there was a global limit of 250,000, or whether it applied per premises. And that is an important practical side of the decision, which perhaps hasn't got so much attention as the focus has been on the NDA clauses themselves. So there was detailed reasoning. The judgment's 242 paragraphs, and although Mrs. Justice Cockerill acknowledged the similarities between the wordings in Arch, she said they weren't close enough to cause her to follow them. She also said that the clause shouldn't be narrowly construed to cover local dangers. A danger or a transient incident posing a risk to health and safety did not have to be limited to those circumstances. Interestingly, she departed from the reasoning of the Irish court, saying that it was, in this case, inappropriate to place too much emphasis on paradigm examples, by which I mean picking out a danger or disturbance, like a bomb scare, that obviously does fall within the clause or not. Or, for example, she said, excessive reference to historical derivation. So, for example, relying, for example, on the clause and its applicability to terrorist activity in the 1980s. The word danger, she held, could cover disease in the context of illness and infection. She also said the word danger, as you would have spotted in the clause as it came up, was not paired with the word local, and the word in any other statutory authority in the clause was wide enough to cover the central government. She's also made reference to the MSD clause, murder, suicide, and disease, which did not exclude COVID-19. The natural reading of that clause was that diseases on the excluded list, not on the excluded list, could therefore be covered. She also drew, as I said earlier, on the Supreme Court's approach to causation. And also she said that there were material textual differences in some of the descriptions to that had been used in the divisional court in Arch. As I've also indicated, the second part of the decision was on limits. So the policy named the insurer as Corbin and King Ltd and subsidiaries. And the actual full client name and all the different 11 companies were listed in a schedule. Now the policy limit provided 250,000 under the NDA clause. The parties disagreed over whether that applied for each closure of a single limit across all premises or whether a separate limit per premises. Mrs. Justice Cockerill concluded that it applied to each premises rather than across all of them. She said the policy was construed as a composite policy and each to be treated as separate contracts of insurance with each of the insured entities within the Corbin and King group listed in the schedule. And that construction was supported by each of the premises having a separate limit. Interestingly, the judgment has not been appealed. So that case will have significant impacts for other policy holders who are obviously awaiting the outcome of this decision in respect of their own BI losses under that clause. As I said earlier, the decision was consistent with the obiter of Lord Mance and the Supreme Court's approach to causation, albeit on the disease wordings. The FCA have produced a document dealing with the decision. They have suggested its implications could go further than NDA clauses. It also advises insurers that in terms of rejecting and settled claims, that where a policyholder accepted a full and final settlement offer and the related communication was clear, fair and not misleading, that settlement will still be binding. However, if there is a need to revisit claims previously rejected in reliance on limits within the policy wording, if the amount would have been significantly different had the reasoning in Cockerill's judgment applied. Finally then, as I say, the main focus on this case has been the construction of the NDDA clauses. But in terms of business side of things, particularly insurers like AXA, it may be that the second part of the decision to do with the limits and the wording of who it covers is actually perhaps the more important issue and perhaps more relevant to the level of business underwritten. And there seemed to be potentially a lack of clarity within the structure of the policy. Multiple entities, as you saw, were listed as insured, and sometimes, Perisher thought, underwriters might just misunderstand and think, oh, that's just the same client, rather than 11 different insurers. And Perisher thought that brokers may think the same. So the policy was treated as a composite policy, and every entity had a standalone right, as you see, to claim up to the limits for each premises. Thank you. Over to you, Guy Blackwood KC.
Just picking up from what Joe said, I do think the distinction between joint policies and composite policies is going to be very commercially significant. And we've not heard the end of that, because it makes the difference potentially between a modest or even small claim and under some policies a very large one indeed. So I think Corbin and King and the principles touched on in that judgment will come before the courts again before too long. But I'm going to talk more about the reinsurance angle of things and aggregation. What is it? It's a very simple concept. It is a means by which you treat a plurality of linked losses as though they were one. There are two elements to an aggregating clause. What is the aspect of linkage or causation, and what is the unifying concept? Event, occurrence, and cause are three of the more common ones. They're well known. They require a unity of way, time, and place. But this has come under quite sharp focus in a recent decision known as Stonegate, which makes for a good read if you've got a spare week or so. It's a dense, lengthy text, but it does go into aggregation in some considerable detail. And the birthplace of the modern law of aggregation is the Dawson's Field arbitration, which does repay a read. Unlike Stonegate, it is only 10 pages long, so if you can bear half an hour or so, it's worth trawling through. It's the well-known case of, I think, 3 or 4 planes, passenger planes, all bound from Europe for New York. They were hijacked by the Popular Front for the Liberation of Palestine, as they were then called. 3 of them were taken to an airfield in Jordan called Dawson's Field, which was controlled by that group. A 4th was taken to Cairo and blown up. In time, the other 3 planes with hostages were also blown up, although fortunately the hostages were not. And the question which arose was, well, how do you assess unity of way, time and place? What do you take into account when you're looking for a single event, occurrence, or, although it's slightly different, cause? I won't go into that now. And what Michael Carr did in the Dawson's Field arbitration was to suggest an informed observer or scrutineer test. He said, put yourself in the position of the informed observer at Dawson's Field in September 1970, watching the preparations for the blowing up of the planes, the evacuation, and the immediate aftermath. In other words, at least the suggestion has been taken to mean the assessment of whether or not you've got one or more events or occurrences is to take place at the very time of the occurrence itself. It's the temporal element of the informed observer test, and that came under scrutiny in Stonegate. So Mr. Justice Butcher, who was the judge in Stonegate, held that it was very artificial to suggest that the judgment was to be made at the time of the occurrence itself, that there was not to be a contemporaneous judgment. Relying on the Australian decision of Marrickville and Swiss Re, he placed reliance on what he viewed the purpose of business interruption insurance to be. In other words, payment to an assured relatively quickly to keep the business as an ongoing concern. And that, he said, that meant that when applying the informed observer test, the relevant time for the judgment was relatively soon after the event. In other words, he focused on the business interruption element of the policy and the need to put the company in funds so it could continue, and not necessarily the disease aspect, the fact that one was looking at a very fast-moving pandemic, COVID. So the information he thought the informed observer ought to possess or be taken to possess was information available up to the end of March or early April 2020, which included a WHO bulletin on COVID of that date, but not information that came along later. In connection with was taken the words of linkage to be a relatively loose requirement, not incorporating anything like proximate cause, but something more similar to an indirect cause, some sort of loose relationship, which was a bit more than what might be called an item of history. And just to make sure that they didn't miss a trick, the assured in that case put forward at least 19, I'm sure there were more, alternative suggestions for the identification of the relevant occurrence, nearly all of which were rejected. The first was a single case of COVID within the relevant geographical radius. I don't remember what it was then, but it's typically 25 square miles or kilometres. And the judge felt that no individual case of COVID would stand out, so he rejected that. The next suggestion was the initial transfer of the virus to humans, which the judge regarded as being too far removed from the losses to be the relevant aggregating occurrence or event. And that is notwithstanding the very rapid transmission of the virus, but both within the Wuhan area and indeed internationally. The next suggestion made was that the tipping point was the relevant occurrence, but I think unquestionably rightly on this particular point, a tipping point is a very difficult thing to judge. It's really a state of affairs rather than a particular occurrence or event, and was rejected as being an occurrence or event. And if you look at how COVID spread, I think there's force behind that. For example, when it came to Europe, I think the latest information suggests the first 2 cases were one in Italy and one in Germany. The German case was contained, did not spread. The Italian one did spread. So a tipping point is a fairly fluid concept with a pandemic such as this. And I think the judge was right to reject that possibility. But his finding that the informed observer was to take a view in March or April 2020 necessarily meant that specialised information about the virus and its spread, which came to light or was only just coming to light at that time, was not to be taken into account. And so the informed observer was not to be imputed with the full knowledge of COVID as at the date of the trial. What was held or were held to be potentially aggregating events, and this could be of importance with reference to matters, for example, that have taken place recently in Eastern Europe and elsewhere, was a decision of COBRA in March that the public should be advised to avoid pubs, restaurants, and the like, and a subsequent decision a few days later where those same establishments, pubs, bars, and restaurants were told to close and not to reopen. So the events were held to be decisions or decrees, but not anything directly related to the virus or its spread. Now, why might this be relevant? Well, the first and obvious, and that's the best picture of a raccoon dog I could find, and not my caption. The first and obvious is that obviously Stonegate, as I understand, is under appeal. It's not very surprising given the number of findings and the relatively novel findings. But there has been some recent evidence made available in the press, which I think suggests quite strongly that the source, or at least the intermediate source of the virus, the COVID, was the raccoon dog. It was regarded as a possibility in Stonegate. If the media reports are to be believed that are coming out now, it might be rather more than a possibility and may well be on the way to sending lab theory, as it were, to the sidelines. We'll wait and see. Apparently information was posted on various servers and disappeared rather rapidly thereafter. So whether that is retrieved and what's made of it, we wait to see. But it does seem likely that the source was a raccoon dog in the Wuhan wet market, one or more. I've asked the question here, how well informed is the scrutineer? And this, I think, arises in the COVID context when you look at suppressed information. This is information that might have been available from day one, but was not made available or disseminated to the public at large. So let us assume that these tests of raccoon dog serum were actually taken out contemporaneously or near contemporaneously in Wuhan. That would have been information which was contemporaneous, could have been made available contemporaneously, but was in fact suppressed. Is that relevant when one's looking at an aggregating event or not? And it may well be important because it might be possible, may not be of course, but it might be possible to say with a great deal more certainty when the virus passed, how it passed, on how many occasions it successfully passed, because it's likely to be the case that there were more transmissions than the fatal ones, as it were, that led to the transmission of the beta virus. And these are all questions which at least potentially could influence the court's thinking about identification of the relevant occurrence in this particular context. And the final point is decisions. There's a very general paragraph in the judgment of Mr. Justice Butcher. Whether or not a decision will be an occurrence depends on all of the facts and the way in which the decision was made, etc. It is not specific. So there will be opportunity for debate in that regard, doubtless going forwards in other contemporaneous contexts. So that's what I wanted to say about a very long judgment in a very short talk, hopefully without being too prosaic, but it's a moving feast, and I think it's something we're likely to hear more of, both in terms of Corbin and King, in terms of geography, the limits of, if there are any, of the FCA case, and identifying aggregating events for the purpose of principally reinsurance with COVID-19. So I hope Will, as I said earlier, is an absolute expert on answering questions. The more complicated, the better. But we're very happy to try to answer anything that anybody has. Of course.
Hi, Will. Or three. Clearly, disputes are clearly ongoing. Sorry, if I start speaking. What are your thoughts on Section 13A damages as a result of, it's been 3 years now since the start of the pandemic and these claims were notified?
My thought is it's tremendously difficult to prove. I've tried it. By and large, people ultimately don't bother. I think it would have to be a very large claim and analysed very carefully by forensic accountants, because you have to show, obviously, that late payment is a cause of loss and what that loss is. So whilst theoretically available, I'm not aware of a case in which it's successfully been proved. It will doubtless one day happen, and it may well be a COVID case or other large insurance claims, but it will require some very detailed causative proof. No? No.
I haven't seen it run successfully.
No. It's always pleaded, but never usually fully developed.
Good evening. Thank you for the 3 acts. Thank you for some listens. My name is Aggregation. I'm a consultant with Separate, a smart partner, example. I've been out of this particular thing for a while, but I did watch the FCA case online from home, and it was fascinating. The particular case I've got raised an interesting question of the relationship between SARS-CoV-1 and SARS-CoV-2. We often hear that the pandemic was unprecedented. A friend of mine was actually in Wuhan in 2003, working for the World Health Organization, and arguably she and her team prevented the SARS-CoV-1, which she and her team in Geneva and a filled room in the early hours morning identified as SARS severe acute respiratory syndrome. And then in 2005, when I think Bill Gates was expressing his opinions in Davos, he suggested the biggest problem for the world was a pandemic. I'm not aware myself, but I haven't been closely involved in this for some while, of any cases where expert scientific medical evidence has been used to explain the connection between SARS-CoV-1, SARS-CoV-2, and what underwriters of property insurance covers with business interruption extensions knew or ought to have known. So I stand to be corrected, but I'd be very interested to know if you know of any such cases. Thank you very much for the presentations.
I mean, I don't know yet of any cases where there's been a comparison between SARS-1 and SARS-2. I think SARS-1, which was prevalent in Hong Kong, if it's the spread I'm thinking of, has been shown relatively conclusively to have come from civet cats as the intermediate host. The evidence is pointing towards raccoon dogs for SARS-2, if we can call it that. I think they're both generalist viruses, and I'm not yet aware that there's been any comparison or compare and contrast between the two. But I think going forwards, it self-evidently, at least now, will be in everyone's minds when these sorts of clauses are written. Particularly if the practices that must have contributed to some extent to these epidemics and pandemics, respectively, continue. I don't know whether they do, but if they do, then it would appear to be a matter of when, not if, number 3 comes along.
Exactly. Are we prepared for the next one? I think is the question. So, the journalists.
Perhaps more so with the vaccines than in the past, but no, I don't think anything like that has yet come before the courts, at least not that I'm aware of.
I think it was interesting in the Australian cases that the disease clause in the policies there had included into it an exception for notifiable diseases listed in the Quarantine Act in Australia. And so because of that, for whatever reason, the policy have decided to include that wording. Many of the insureds fell at that hurdle because COVID-19 fell within that exception from the disease clauses, because we didn't have that wording in the test cases. Whether that would have caught that type of.
So, notifiable diseases, of course, is a term of art and written into a statutory instrument, and that did exist prior to the pandemic. Which, if you read a book by an Australian journalist, What Really Happened in Wuhan, she certainly was very convinced that it came out of the laboratory, but I think there's no doubt that it came out of Wuhan. Whether it's the laboratory or the wild animal market, I think is a moot point, and will never be established because all the evidence has been displayed. Thank you very much.
Hi, thanks for the presentation. I just wanted to get a bit of an indication from you guys as your thoughts as to how the inability to use point might be interpreted, particularly in relation to the definition of a discrete part of premises. I think the example, perhaps one of the examples used in the test case was a bookshop that had a cafe within it, and the cafe being closed down, the bookshop still open. But I wondered how you see it being a very discrete and delineated part of the premises, or maybe a bit more of a grey area. For example, restaurants that had to perhaps allow entry again, but had to instigate 2 metre distancing such that every alternative table had to be left empty. So they're able to be open, but there was an inability to use because they could only use half of the tables. And similarly, things like beauty salons, hairdressers, etc., had to separate their customers. What's your views in relation to the interpretation of that, and whether that would actually trigger as an inability to use, or whether something more discrete and delineated and very clearly separated would be required to trigger that sort of definition? Thank you.
I mean, I think it's a really interesting question, and it would be surprising if, for example, you could just arrange the footprint of your business in a different way and because you did that, you could recover, and if you didn't do that, you couldn't recover. It seems to me that the idea that the businesses could operate but with a 2-metre restriction would, on first impression to me, appear to fall more into something being a hindrance rather than a complete inability. To my mind, to show a complete inability as to part of your business operations, I think you'd be looking at trying to show that you can circumscribe and set apart that particular operation. In other words, the staff that deliver it, the management chain up through the business, the way in which it's accounted for, to say that that is part of the business we couldn't do during this time. We just couldn't do it at all. And if you can do that, you're probably within the inability to use concept that's articulated in the FCA case. And if you can't, it's going to be rather more difficult, I think. And with discrete parts of the premises, again, I think it's sort of the notional shut door that you've been able to put on that part of your business, or something that you could put a cord around it and say that that was the part that we just couldn't use at all. That's the type of arena you have to be in, would be my initial impression.
I agree with that, but it's going to be tremendously wording specific, that sort of, and fact specific.
And it hasn't arisen, it's an issue that hasn't arisen as much as, because, for example, in my case, this was 2020, and there was a total lockdown. Some of the scenarios you envisage, when the regulations changed, it became a little bit more bespoke, or some say confusing, about what you could do and bits that you could do and times and so on. So most of the cases seem to be focused on that 2020 hard lockdown period where that issue hasn't arisen. But I think it is an interesting point. Thank you.
I mean, if there's nothing else, thank you very much for listening. Thank you very much for coming along. We can declare this definitely a COVID-free zone. So thank you very much.